Welcome to Notable Approvals. I'm attorney Amanda Shaffer. Before we get to our case today, hopefully this is working on Instagram today, but we're also on Facebook and YouTube. But before we do get to our case, don't forget to like us and follow us on Facebook and Twitter and Instagram and LinkedIn, and follow us on YouTube so you don't miss any more of our lives. Today we have a very exciting case to talk to you about. A client who has been through quite a lot to finally get her green card. So this client is a native and citizen of Mali. She first entered the U.S. back in 1998 with a B2 visitor visa. She actually was married to her husband a year earlier back in Mali in a religious ceremony. And I've talked about marriages before that there's no paperwork, some of these religious or more traditional weddings, that can make things a little difficult. And in her case, there was an issue later on, but they were married, they came to the US together. After they came to the US, they both filed for asylum. Now, when she filed for asylum and her husband did, we were not her attorneys, so I'm not sure exactly what happened, but he was granted asylum and she was granted withholding of removal. Now, my assumption is that usually happens when you do not file within a year of entering the country. So maybe her husband did, but she didn't. That's my best guess on what happened with that. However, had she been able to prove that they were married, she could have gone on his asylum application as a derivative and not had to file her own, or he could have gone on hers, vice versa. And if he gets granted asylum, then she would have gotten granted asylum. But because they didn't have a paper to show that they were married, when he got granted asylum, she didn't automatically get granted. And she did have her own application, her own reason for asylum. But again, I'm pretty sure she filed outside of the 1-year filing deadline, so she got withholding of removal. And a quick recap of withholding of removal: it is like asylum in that it's the same application. It offers it. You apply for the same reason, that essentially that you're afraid to return to your country on account of one of those protected grounds: race, religion, nationality, particular social group, ethnicity, and that you're likely to be persecuted in the future. Now, there's some key differences here. One being, you're eligible for asylum only if you file within a year of entering the US, with some very narrow exceptions. Withholding, you do not have a time limitation. But when you apply for asylum and you get it, you can get a green card, eventually citizenship. When you get withholding of removal, you actually have a removal or a deportation order, but the government is literally withholding from executing it and allowing you to remain in the US indefinitely. Now, there's ways to deal with that order of removal, which I'll talk about in a second. But the other big thing to keep in mind is when you're granted asylum, even if you decide I don't want to get a green card, you can remain in the US forever, work without having to apply for a work permit every year or every 2 years. You're eligible for asylee travel documents. If you have withholding of removal, you can't leave the US. If you leave, you're removing yourself or deporting yourself. You have to apply for a work permit every year and renew it. So there are some really important limitations. And then the other thing is, if you have any derivatives, so a spouse or children under 21 who are on your application, they can't get granted withholding of removal too, but they can get granted asylum. So keeping all of that in mind, she's granted withholding of removal, he's granted asylum, he then gets his green card. So now he's a permanent resident, and unfortunately, that's when he began abusing her. And again, we started representing her shortly after this. I don't know all the details, but I know it was, from what I remember, it was pretty bad. But she has this removal order, so it's not like she could just easily apply. She could apply for VAWA, but that's what she did. She just did the VAWA portion. Once that was granted, then we had the issue of the removal order. But she has withholding of removal, not just an order of removal, which is a humongous difference. And if you were watching any of my updates yesterday, was it yesterday or yesterday and a few days ago about the Biden administration and the freeze on deportation, or not freeze, blocked freeze now on deportation, but how they're looking to possibly reopen cases or find alternatives to removal. She's someone with withholding of removal that would likely find it easier to reopen if she had a hard time before. We moved to reopen her case right at the end of Obama's second term. So I'm not sure. I think it was a little harder under Trump in the same situation to reopen cases. But the reality is she's now eligible for a green card. They're allowing her to remain in the U.S. indefinitely. It doesn't really make sense to deny this type of motion to reopen. So the way we did it is we made a request to the Department of Homeland Security to join us in a motion to reopen and terminate. So we don't even have to go back to court. And she has no criminal history. She was a victim of abuse. She had the approved petition. We waited for the visa number to become available because she was married to a permanent resident, not a U.S. citizen. So it wasn't, at that time, it was like a 1.5 year wait, which wasn't a big deal by the time the VAWA was approved. And DHS agreed to join us in the motion and terminate her case. So we filed the joint motion. The judge granted it, which was fantastic, which meant the judge could have reopened her case and she could have gotten her green card before the immigration judge, but that generally takes a lot longer. And honestly, I think it's a waste of court time because she was adjustable with USCIS. So we then filed her Form I-45, or application for adjustment of status to that of a lawful permanent resident. And it only took 8 months for it to be approved, which, especially when it was approved, the wait times were like over 2 years. So that was pretty good. And at this point, I believe she has a couple more years before she's eligible for citizenship, because if she was married, if her husband was a U.S. citizen, then she could have filed after 3 years of having her green card as an abused spouse of a U.S. citizen. But abused spouses of permanent residents, just like spouses of permanent residents, have to wait the full 5 years to apply for naturalization. So what I really like about this case is that there's a lot going on, but nothing was too complicated. It's fairly straightforward. And everything, although it took time, because all these things do, everything worked out as planned. And we're really hoping that there's more cases we're going to be able to reopen in the next 4, possibly 8 years, that for people who, like if she just had an order of removal, we could have possibly gotten her case reopened with the VAWA, but it's a lot harder. And DHS might not have joined us. So if they didn't join us, it's not really a guarantee. We have one case right now, actually, in the BIA at the Board of Immigration Appeals, because this client a long time ago got an order of removal and appealed it and lost the appeal. So then she got VAWA approved, and we had to file a motion to reopen with the Board of Immigration Appeals. We did ask Department of Homeland Security to join us, and they did. So it's just a matter of time before the BIA reopens it. So, VAWA cases are a little different, but it's no guarantee if you have an order of removal, but it's definitely worth a shot. So if you or anyone you know are in this position, or have any questions about your immigration case, our contact information has been scrolling across the bottom of your screen. Do not hesitate to contact us. Oh, and a quick reminder that next Thursday, February 3rd, 2021, at 9 p.m. Eastern Time, we will be having our first episode of our new game show called Are You Smarter Than a Naturalized Citizen? This is a can't miss, especially if you're studying for your naturalization test. We have 2 immigration attorneys, attorney Agi Mangone and Elizabeth Murr, going head to head to see who can get to 12 correct answers first. You have to get 12 out of 20 answers correct at your naturalization test. So it's just a little fun way to let people know what the questions are like and to see how hard they are. So please don't forget to join us. We have an event page. Find it on our Facebook page and set your reminder. And also like us and follow us on Facebook, Instagram, YouTube, Twitter, LinkedIn, all that lovely stuff so that you don't miss another live. That is all for today. Thank you all for watching, and we'll see you. Tomorrow's Friday, so I'll see you on Monday for another notable approval.